Good morning. Today is Tuesday, May 28th, 2024. What is it? Rosalie? Oh, okay. Sorry. All right. This is the South Coast Air Quality Management District Hearing Board, and we are here for the modification for an order for abatement regarding Flex Firm Holdings LLC, case number 6239-1. It is the 28th of May, and we are going to start this meeting, just opening it up, and then we are going to go into a recess since the attorneys are still discussing matters and we're still waiting for a document from that. So if you can go ahead and put us into recess and stop the recording.
How long? Yeah.
Yeah.
You want to say until 10?
Oh, day, we're going to go ahead and try to begin at 10 a.m.
Okay, I'll wait for your
Thank
cue.
you. Okay.
Can I be promoted to panelist? For the Zoom?
Di, did you?
If I could be promoted to panelist for the Zoom, thank you.
Josephine?
Yes,
Okay, let me move you over.
thank you.
No problem. We're still in recess, correct?
We're going to begin in just a moment.
I'll stop the timer.
Okay, I believe all the parties are here. You can go ahead and start the recording. Are you ready, Madam Clerk? Okay. All right. Again, this is the South Coast Air Quality Management District Hearing Board. It is the 28th of May, and we did take some time to allow the parties to have discussion, as well as we still need time to read the documents that have been given to us. However, let me do a little bit of housekeeping before we do that. According to the minute order, we had two members of the existing board who were not there for the hearing on the 25th of July of last year. So I'm just asking if you were able to bring yourselves up to and look at the documents for today's hearing.
Yes, Madam Chair, I was able to review the materials.
Thank you, Ms. Dr. Abraham.
Yes,
Mr. O'Leary?
I also reviewed all the
Thank
material.
you. Okay. And there's no objection from either party that they are going to participate today?
No objection from the district.
Okay, all right, so let's just go ahead and ask who is here on behalf of the district.
Good morning, Josephine Lee, on behalf of the executive officer, and I have my colleague here.
Sherry Hani Zavara, also on behalf of the executive officer.
Okay, and on behalf of the respondent.
Tony Endress, Furnace Dynamics for Flex Firm.
Can you spell your name, sir?
Yes, ENDRES.
And your title?
President. President. Oh, Tony. Anthony.
Okay, and will you be having another witness?
No.
Yeah, Albert Castillo, General Manager at Flexprom Products.
Okay. All right, we did receive some documents. I'm going to go ahead and mark the exhibits before we do take time to read the declaration as well as the new documents. On exhibit number 3, that will be the letter dated January 11th of 2024, addressed to Ms. Reichert from the district. Yes, that was attached to the petition. And my question, all of the documents that are behind that letter, are you including them as exhibit number 3, Ms. Lee? That's another document. That's the permit to operate. But there's a lot of documents between the page of number 3 and the pages of number 4. So I'm just going to include them in number 3 is what I was going to do, and asking her if that's what her intent was.
Yes, that's right.
Okay. And then the exhibit number 4 will be the permit to operate. And there are some documents that are behind that, but it's strictly number 4, the permit to operate. Number 5 are the proposed modified conditions. And number 6 will be the declaration of Austin Stewart. And we also have received a printout, a spreadsheet, it looks like, of the best available control technology guidelines for non-major polluting facilities. This is coming from the respondent, and that will be exhibit E as in Edward. And if all of these can be entered into evidence, Madam Clerk?
I have a question.
Yes.
So you mentioned the permit to operate. Is that the one that's G75719 in the upper right-hand corner?
I believe.
Yes, that's correct. It was attached to the declaration. Or I'm sorry, that was attached to the petition and courtesy copies were also provided. So you may have a duplicate of 75179, but additional copies were provided of the G 52. Let me,
678?
that's correct.
So my question, is that a separate exhibit or is that, how are we dealing with that one?
Yeah, G 52678 can be marked as a separate petitioner's exhibit.
Okay, so let's go ahead and mark that as 7.
Thanks.
Thank you, Mr. Pearman. All right. So in order to give the board members adequate time to go over the new document, let's go ahead and take is 15 minutes enough, board members? Okay, we will take 15 minutes, go off the record and come back. Yeah, I can't, I think it's 10 after.
It's fine.
Okay, so 15 minutes from this point. If you can go ahead and stop the recording, Day.
Do you want a copy of the conditions? Maybe.
the hearing. I'm going to ask. Okay. Dave, you can go ahead and start the recording. Okay. All right, so we'll resume the hearing for Flex Firm Holdings LLC, case number 6239-1. We have already identified who's representing the district as well as Flex Firm, and I'm going to ask now, will you be having any witnesses, Ms. Lee?
Yes, the district plans to call Mr. Austin Stewart from engineering, as well as Mr. Adam Martinez from compliance.
Okay. And Mr. Enders, are you going to have witnesses?
Only Albert.
Okay. All right. So all of those, are you going to be testifying also, sir?
Yes.
Okay. All of those who are going to be providing testimony, if you can please stand and raise your right hand. Do you swear under penalty of perjury that you will be telling the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. All right. We have all of our exhibits. If we can go ahead, you can start, Ms. Lee, with your opening statement.
Thank you, Madam Chair. I'm going to share a screen. I have a PowerPoint presentation. Let's see. Is it showing up? Okay. Good morning, board. Thank you for giving us some time this morning. We've been working throughout this weekend and this morning to try to reach stipulation as to some of these conditions. We did provide the updated proposed modifications marked exhibit 5, I believe, but they were written this morning. So please forgive any typos or anything if they need to be corrected. More than welcome. So today before you is a hearing to modify and extend an order for abatement involving Flex Firm Holdings LLC, case number 6239-1. Respondent Flex Firm operates a textile coating facility in South El Monte. The textile coatings operations are conducted under 2 permitted lines. The first is a drying curing oven under permit to operate G75179, also referred to as a non-VOC oven. That was marked Exhibit 4. The second is a drying curing oven with an afterburner, which is a control equipment, under permit to operate G52678, which I'll refer to as the VOC oven and afterburner. That was also marked as Exhibit 7. Briefly, just for the members of the public that may be participating as they may have been impacted by these operations, I wanted to go over what an order for abatement is. An order for abatement, this was taken directly from our website, requires a company operating out of compliance to take specific actions or shut down its operations. It's a severe remedy normally reserved for serious violators. Under an order for abatement, the facility is required to immediately cease and desist from violating district rules, or they can comply with alternative conditions. Overall, the purpose of an order for abatement is to reach compliance on an expedited schedule. It can be stipulated to or contested, and it is not a variance. It's not a temporary relief from complying with district rules. As you raised, Madam Chair, we're coming back to this hearing board. There was a hearing already held in July 25th, 2023. It was a stipulated order for abatement. In the petition, the district had raised alleged violations of rules 203, 1128, 1147, 402, and the analogous California Health and Safety Code 41700 for public nuisance. After that hearing, or during the hearing, I should say, Flex Firm stipulated to the conditions, meaning they agreed to perform the required conditions, which included a source test of the afterburner to demonstrate compliance with the VOC destruction efficiency under Rule 1128. Permit applications, to submit the necessary permit applications to update equipment description and incorporate required conditions. And we also agreed to further evaluate Rule 1147 applicability. The hearing board made the good cause findings to grant that stipulated order. I'll come back to this. Since the July 2023 hearing, I'm sorry, it's not updating on. There we go. I'll just continue. Since the July 2023 hearing, some conditions have been met, but not all. And I had intended to try to outline that in the petition for this hearing. Fortunately, there are ongoing violations of public nuisance. Since the July hearing, the district has issued 9 additional NOVs, 8 of which were for public nuisance. The most recent was issued on May 10th. An additional NOV was also issued for violating this hearing board's order. At this time, facility has not demonstrated compliance with Rule 1128, the afterburner VOC destruction efficiency. There were some additional concerns that staff had raised when they received the safety data sheets. I believe it was earlier this month that they were received. And so the proposed conditions aim to address those concerns. Additionally, all permit applications have not been submitted as stipulated to under condition 5. I'll go over just specifically here, and I'll try to do this briefly, but again, just to refresh this board's recollection and for any members of the public who may be listening in. For condition 1, the facility did meet the condition, which was to submit the source test protocol. Condition 2, they missed the deadline to conduct the source test. They attempted to conduct the source test by that October deadline, but were unable to do so. And so they conducted the source test in November. Condition 3, they did conduct the source test, but the results were non-compliant. Rule 1128 requires a destruction efficiency for VOCs of at least 95%. The source test results from that November 2023 test demonstrated a VOC destruction efficiency of less than 75%. So this is a fairly significant deviation. Condition 4, slightly missed, 1 day late, the compliance plan was submitted. A copy of that letter has been marked Exhibit 3. To address the outstanding 1128 rule violations, the district has proposed conditions 6 through 13. There are 2 options, essentially. Either do another source test to ensure that you can demonstrate compliance with Rule 1128, or submit permit applications for new equipment, as there may be concerns that this current equipment may not be able to meet the standards. There are additional conditions to ensure compliance with Rule 1128 as raised by the safety data sheets that were received, and which include testing the VOC for all applied coatings and ensuring that the coatings that are applied meet 1128 rule limits and the permit limits. As of this morning, we've reached stipulation as to conditions 6 through 13. The July order also included condition number 5, which broadly required the facility to submit all necessary permit applications to ensure that the permits reflected the equipment at the facility and incorporated all necessary permit conditions. As outlined in the declaration from our engineering staff, marked, I believe it was marked Exhibit 6, this condition was not met. There was a permit application received, but was unable to be implemented as requested. Several correspondences from engineering staff to try to get the correct applications. To this date, it's the district's position that this condition has not been met, which is why the district has proposed conditions 19 through 22 in order to effectuate what was originally intended in condition number 5. As of this morning, the facility has stipulated to these conditions. The July hearing petition had alleged a violation of Rule 1147. As this hearing board may recall, a week before that hearing, respondent had contested to the applicability of Rule 1147, and the parties agreed then to further evaluate whether 1147 would apply. Since then, it's the district staff's understanding that the afterburner may be exempt from emission standards under the less than 1 pound per day of NOx. I'll call it an exemption under Rule 1147 subdivision G. And we've provided conditions, proposed conditions 14 through 17 to ensure that the facility remains below that 1 pound per day of NOx. This is the only issue that we come before you contested today. And I'll allow the facility to discuss further, but we're prepared to demonstrate as necessary under hearing board findings that the facilities is in violation of Rule 1147, and the conditions we hope will ensure compliance. And finally, as is always a concern and an ongoing concern, is how this facility's operations and the violations are affecting the public. As I mentioned earlier, there have been 8 notices of violations issued since the July hearing. Even at that hearing, I believe there were 4 or 5 NOVs. So we're at a total of maybe 13, 14 odor nuisance NOVs in the last perhaps year. And this is definitely a concern. We're hoping that compliance with the proposed modified conditions, particularly with Rule 1128, will result in mitigation of these odor issues. But we have proposed to come back before this hearing board in a status hearing in September, as district staff will continue to respond to any complaints, and we can reevaluate if further modifications will be needed. As I mentioned, the proposed conditions request for a status hearing to be scheduled in September. When the time is appropriate, we can determine what that day will be. And as wasn't the case in the July order, we have included the conditions that the hearing board may modify the OA upon a showing of good cause. And we're requesting to extend this current OA, which is set to expire at the end of this month, through December 13th, 2024. I would just like to finish and say, this hearing is unique in that this is not the first time before the hearing board. This is a modification extension from what was already granted, conditions that were agreed upon and have not been met. We could have come in to ask for a shutdown because that is one of the options. We're willing to give the facility a little more time with very strict deadlines, but have the ongoing concern of public nuisance. And really the intent of these proposed conditions is to ensure immediate compliance because the time for compliance is now. Thank you.
Thank you, Ms. Lee. Okay. Mr. Enders, you can go ahead and make your opening statement.
Yes, we would like to articulate the fact that we believe. Is that better? Okay, good. That the afterburner is exempt pursuant to 1147 and BACT guidelines. You have been submitted BACT guidelines that indicates that if the vapors go directly into the burner, it is exempt from the ppm limits. And to provide some background on this, the BACT limits and the new rule limits are based on a type of afterburner that has an air-fuel ratio control system, including a combustion air blower method of controlling that air-fuel ratio at a certain given ratio throughout its firing system. This particular afterburner does not have that. It's a fixed air gas modulated system. So it can't maintain a proper air fuel ratio control throughout the whole system. The fact that it goes through the burner, all of the BACT guidelines and source test data was not based on this type of application. And staff in their rule and also in the BACT guidelines acknowledges this pursuant to the exemptions in Rule 1147. So we believe that because this is a unique, somewhat unique type afterburner, that 1147 does not apply to this device. And therefore, some of the conditions that have been articulated by staff do not apply. One of the other conditions is that during this whole process, there were two permits, 52678 and 52680. The 52680 was the actual correct definition. On the 52678, it calls for a 30 horsepower circulating fan on a 1.5 horsepower motor. There's no such thing, never has been anything like that. There is a 30 horsepower circulating blower on the oven itself. So that particular call out, the correct, everything else on the 680 is correct. Both those are identical to each other. Somehow there was a confusion as to which of the two applications actually applied. I should also indicate that in the conversion from FlexFirm products to FlexFirm Holdings, for some inexplicable reason, there were two permits issued for identically the same device. And that would say that there is two afterburners, two ovens, which there had never been. So the second one was an error from the get-go. There was other errors in the process where the small oven wasn't picked up by staff during the time that the conversion was made. All the definitions that are on the small oven permit are correct. So there is no need for any additional permitting action there. We also feel that should in the conversion, should staff had wished that there was a bifurcation of the afterburner and the oven, it should have been dealt with at that point in time. So those are a couple of things that we would like to consider, the board to consider. Let's see, the new device that we're looking at going to do another source test. We agreed to doing another source test. Should that source test fail, we are in the process right now looking at a carbon capture system that the manufacturer is in the process of providing a guarantee and a quote for FlexFirm. They are going to guarantee 95% destruction efficiency and elimination of odors. So this is an ongoing process. And we looked at a number of different applications, this type of application. Most of them are not anywhere near the local area. So the carbon capture outfit in Torrance has an international company with like 7 different facilities worldwide. They believe that they could provide one of these systems in a relatively short period of time, and they're in the process of doing that with a quote. So should the afterburner source test not prove the 95%, destruction efficiency, we will already have this in place to immediately activate the purchase of a different system, in which case the afterburner would be irrelevant. So it would take the place of the afterburner and satisfy the destruction efficiency and also the odor issues. I think that is basically where we are right now with this. So we are pushing forward. FlexFirm has spent about $40,000 or more to correct some of the problems that they had with ducting, internal portions, cleaning, and so on and so forth, replacing all of in the heat exchanger, replacing all of the tubes to make sure that there's no additional leakage or anything there. So there's an ongoing effort to try and comply. So I think that will satisfy my requirements at this point. We respect your opinions and resolutions.
Thank you, sir. Okay, Ms.
Can I just get a clarification of what he said when we were talking about?
Okay.
Because my notes show the district said conditions 19 to 20 were stipulated, but you seem to be questioning the need for the permit application, modification, and restructuring. So please clarify, do you agree to 19 to 21 or you don't?
19, because everything is.
Do you agree to 19? Yes and no?
No.
Okay. And 20? Do you agree to 20?
Yes.
You agree to 21?
Yes.
Did I misstate what you said, Counselor? I thought you said they all three were stipulated, but now you understand it's only 20 and 21 on the record, okay?
Yes, thank you.
Does it make sense to stipulate to 2 and not 3, or do we have to look at all 3, or can we just look at the one that's in dispute?
That's fine. It was different from my understanding, but we're prepared to
Okay.
Thank you.
go
All right.
contested.
Okay, Ms. Lisa, you can go ahead then and call upon your first witness.
I'd like to just ask for the hearing board, since we have some matters that are stipulated to and some that are not, would the board prefer us to kind of bifurcate those or go over? I just don't want to confuse what's been stipulated to and what hasn't.
Madam Chair, just a point of clarification. Initially, we were under the supposition that an agreement had been reached, which is why it took us 30+ minutes to commence the hearing. The gentleman stated that he has consternation with one of the conditions. So where did we ever derive, or how do we derive to the point of everybody agreeing on a stipulated set of modifications and conditions when he's contesting? So perhaps should they caucus again so that there's a measure of clarity before we begin the process? Because it seems as if I'm slightly confused.
Well, let me ask this. Is that something that you think, Ms. Lee and Mr. Enders, that you can, if we give you the time to discuss the ones that are not, that you do not agree, that you can discuss it with Ms. Lee and her staff to see if you can come to an agreement? Or is it fruitless? Would it be fruitless?
I'll defer to the facility. As I mentioned in the opening, conditions 19 through 21 were intended to effectuate what the parties had stipulated to under condition number 5. And so there really isn't any change that the district would propose.
Okay.
Correct. However, I would like to know what he is in objection to and why he cannot agree to it, even though it was your understanding he had agreed to it before.
But I do understand that 14 to 18 is still in dispute anyway.
Yes.
So,
Right.
we still have to hear.
Yes,
But I
yes.
like her suggestion, just focus on what's in dispute would be, I think, the best way to go.
Most efficient, I agree. So if we want to do that,
I'll let Tony, if you
Okay.
wanted to respond as well.
Well, first of all, I think it's important for the board to make a determination of the applicability of 1147 on the afterburner. That's critical to a number of the conditions, because if it is deemed to be exempt, then those different issues that were in contention go away. On 19, we believe that all of the information that is on that permit is accurate, and therefore no need for any other additional modifications or applications.
Ms. Lee?
It sounds like we're contested as to those
Mhm.
conditions.
Well, then, as Mr. Pearman stated, I agree that we should go through the ones that are not, that you are not in agreement, so that we understand exactly. However, I do understand his question in reference to, is it relevant in 19 for it to be under that rule or not? Because I very much would like to know if that is the case.
Just so I understand, Madam Chair, then would it be the board's pleasure for us to go over Rule 1147 first?
Probably,
Okay.
yes.
Madam Chair, just one question. Did he ever agree to the conditions as presented to the board?
That was my understanding. And parties have the right, I suppose, to change their minds.
Okay, so let's go ahead and then go over that rule that is in contention here.
Madam Chair,
Well,
I do also like to get some information on compliance with 1128 or proposed, because that's what's causing the orders. And I wanted to know if this conditions will address the orders also. So I can see us focusing on the the contested issue, but I do like to get some additional information on the 1128 compliance, Rule 1128 compliance.
Well, I don't disagree with you. However, I think since they're bringing up 1147 as the most critical right now, why don't we address that first?
Sure.
And then we can do
Yeah,
1120.
okay, like I said, that's the source. 1128 compliance is the source of the orders, not
Correct.
1147 per se.
And on the NOVs, is that correct also? That the majority of the NOVs were in regards to 1128 or?
Regarding odor nuisance.
Yes, okay.
Yes.
All right, but let's address this one critical issue here so we can get that out of the way and determine how we are going to go forward on that.
So to clarify, I'll be bringing, the district will be calling Mr. Austin Stewart from engineering. And this testimony will focus on Rule 1147.
Thank you.
Welcome, Austin. Can you please state and spell your name for the record?
Hi, board members. My name is Austin Stewart, spelled AUSTIN STEWART.
And did you take the oath this morning?
Yes, I did.
And what is your title here at the district?
My title here at the district is Air Quality Engineer Level 2 in Engineering and Permitting.
How long have you been employed at the district?
I've been employed since October 2021.
And were you present at the July 25, 2023 order for abatement hearing in this matter?
Yes, I was present.
And are you familiar with the conditions that were stipulated to under that July hearing?
Yes, I'm familiar with those conditions.
Did you prepare and sign the declaration with your name marked Exhibit C?
Yes, I did sign the declaration.
And do you attest that the statements made in that declaration are still true today?
Yes, I do.
And are you familiar with the proposed conditions marked Exhibit 5? Those were the ones that were submitted this.
Yes, I'm
today.
familiar with the proposed conditions.
Great. So now that we've laid that foundation, I'll be moving on to Rule 1147. Are you familiar with Rule 1147? Let me get the full name of this rule correct. NOx reductions from miscellaneous sources, which was last amended May 6, 2022.
Yes, I'm familiar with Rule 1147.
And not to be duplicative of the information that was already identified in your declaration, but is it your contention that the afterburner at respondent's facility is subject to Rule 1147?
Yes, the afterburner would be subject to 1147.
And the facility, I believe, has raised some exemptions that they believe are applicable. So let's go through them. I'm looking first at an exemption under 1147 M3D. Would it be helpful if I brought that up? Okay. I'll be sharing my screen. Please bear with me. Is this... All right. So can everybody see my screen? I have 1147 M3.
Really
Oh,
small.
it's too small? Okay, sorry about that. Is that better?
Can you make it a little larger?
Okay. Is that
Much better.
okay?
Can you see that, board members?
All right, so Austin, is this an accurate representation of Rule 1147 M3D that I have on the screen?
Yes, that is Rule 1147 M3D.
Okay, and maybe just for the record, can you read what that exemption states?
Mhm. An afterburner or vapor incinerator with a South Coast AQMD permit operating before December 5th, 2008 that has an integrated thermal fluid heat exchanger that captures heat from the afterburner or vapor incinerator and an oven or furnace exhaust in order to reduce fuel consumption by an oven or the afterburner or vapor incinerator.
Thank you. I'm going to try to break that down into elements. So is the respondent's facilities afterburner an afterburner with the South Coast AQMD permit operating before December 5th, 2008?
Yes, it does have a permit to operate before then.
And does that afterburner have an integrated thermal fluid heat exchanger?
No, the afterburner does not have an integrated thermal fluid heat exchanger.
What does this afterburner have?
Yes, the afterburner has a air-to-air heat exchanger to capture heat from the exhaust of the afterburner.
And in your opinion or not in your opinion, but is air equivalent to a thermal fluid?
So air would be the medium of heat transfer, and it would not be considered a thermal fluid heat exchanger.
Engineering.
Therefore, is it your conclusion that the facility's afterburner is not exempt under M3D?
Correct. It would not meet this exemption.
Thank you. Now moving on to M3E. Let me bring that up bigger. Can everyone see that? Okay. Let's see. I want to make sure that you're going to refer to the most pertinent parts, but let's just read all of M3E, if you don't mind.
So M3E says a flare, afterburner, degassing unit, remediation unit, thermal oxidizer, catalytic oxidizer, or vapor incinerator process in which particulate matter, air toxics, VOCs, landfill gas, digester gas, or other combustible vapors are mixed in the unit's burner with combustion air or fuel, including but not limited to natural gas, propane, butane, or liquefied petroleum gas, prior to or at incineration in the unit in order to maintain vapor concentration above the upper explosion limit or above a manufacturer specified limit in order to maintain combustion or temperature in the unit.
Okay, thank you. I'll just stop you there just so that I can make sure that these elements are being met. So here we have an afterburner. I'll highlight that. We have an afterburner here. And is it correct that this is an afterburner in which VOCs are being mixed in the unit's burner with combustion air or fuel?
No, our stance would be that VOCs are not mixed in the unit's burner with the natural gas. The natural gas has a separate fuel line, and the VOC coming from the effluent from the oven, the curing oven, is separate and processed in the afterburner's combustion chamber.
And to illustrate that point, you had attached a diagram of this afterburner as well as this the configuration of the afterburner. So I'd like to point your attention to Exhibit 3 for your declaration. So what are we looking at here with Exhibit 3?
So this would be the afterburner's burner provided by the respondent.
And if I might be going back and forth, so just so that I can be clear with what we're looking at. So this is Exhibit 3, this is the afterburner. And what this piece of equipment that we see here, which I'll describe as a non-engineer as this almost looks like a circular cap with a perforated fan coming out of the other end. Is that accurately describing what I'm looking at?
Yes.
So in Exhibit 4, we have a diagram of the afterburner at this facility. Is that correct?
Yes, that was provided by the respondent.
And these arrows that were those provided by those were indicated by the facility. Is that your understanding?
Yes, the markings with the flow indications were marked by the respondent.
And the arrows where we see here a tube, it almost looks like a flashlight. We have a tube and then the fanned out edge. Is that the same as that afterburner that we saw in Exhibit 3?
To my understanding, yes.
Yeah. And the down arrow coming from the top there, is that what is your understanding of what that arrow is supposed to do?
Ms. Lee?
Yes.
Ms. Lee, except I can,
Can you project it, the actual?
Oh, okay.
yeah.
I'm gonna just need a second to change.
In Exhibit 4, I'm not seeing a diagram.
Okay.
It's in the declaration, not the petition.
Okay. So this was the manufacturer's diagram of the afterburner, which was attached to your declaration as Exhibit 3, correct?
Correct.
And so this image here, I will use my cursor to try to capture it because it is a very small drawing, an old drawing, and we recognize that's what we have. So these perforated edges here and this connection here, this is all the afterburner.
The burner and the afterburner.
The burner and the afterburner, thank you. So if I'm looking, oh, I think this is too large. I think this is the most crucial part anyways. So we have here, my cursor is attempting to circle what looks like what I described as the flashlight, and that is the afterburner.
Yes, the whole drawing is the afterburner, and the arrow or that portion with the cone is the afterburner's burner.
And what is this line to your understanding right here? These lines right here around the I guess the pipe or two part preceding the burner.
To my understanding, that would be a solid box from the prior exhibit.
Okay. And this red arrow coming down, again, I'd like to just repeat now that everyone has this exhibit in front of them. These lines and description, this was provided by the facility, correct?
Yes, it was.
And so this red line here, it's described to, I'm just reading directly from the exhibit, effluent enters behind the burner. Is it your understanding this is the VOC effluent?
Yes, that's the VOC effluent stream.
If this is a solid box, can that go in to your understanding here as the arrow points?
No, it cannot.
Okay. Even if it were not a solid box and this were to come down, Is it your understanding that there is mixing at or prior to the incineration point as specified in Rule 1147 M3E?
So our stance is there's no mixing prior to incineration as they're the separate natural gas and the VOC stream. However, there may be some mixing at incineration point, but there would be VOC bypassing the unit's burner.
And you say because the natural gas line is separate. I'm going to point to what's been marked here as the natural gas inlet, this blue arrow.
Mhm.
So if that's where the natural gas is coming in through here, where would be the incineration point?
So the incineration point would be at the outlet of that tube, similar to the stove on your countertop at home, you know, where the base of the burner at your stove is the initiation of the flame.
Great. And when you say there may be some mixing, it could be that this effluent is coming in, some of it is getting mixed at what I imagine is this incineration point.
Yes, at incineration.
And some of it, as it is a gas, is that correct?
Yes, the VOC stream is gas.
Is then continuing on and passing through.
Yes, passing the burner flame.
And as such, there are concerns that the VOC, not all of the VOC effluent is being destroyed or is being mixed at the incineration point. Is that correct?
Yes.
And so I'm going to go back now to the rule language. Sorry, I have to switch my screen sharing. Okay, so I have up here M3E. And is it true that the exemption requires that the excuse me, that the VOCs are mixed in the unit's burner with combustion air prior to or at the incineration unit? I'm trying to highlight this just to direct the board's attention. Okay, and because it's your position that that's not what's happening according to these diagrams.
Yes, that's correct.
I'd like to also now direct your attention to M3E1. This exemption is subject to the following conditions. Can you read E subdivision 1?
This exemption shall not apply to a regenerative thermal or catalytic oxidizer unit with a burner used to heat up or maintain temperature of the unit, or a unit that incinerates particulate matter, air toxics, VOCs, or other combustible vapors in a gas stream moving past the burner flame.
Okay, so as further description of this exemption, can you explain from your understanding why the diagram we looked at would not be subject to an exemption under M3E subdivision 1?
The diagram provided by the respondent, we're stating that it would have a VOC stream moving past the burner flame and would not meet this exemption M3E.
And finally, I'd like to just, you had included an excerpt from the 1147 staff report, which I will bring up. Here. Is this an accurate excerpt from the staff 1147 staff report from December 2008?
Yes.
And this was the version that was made publicly available. Sometimes there are revisions which are demonstrated in red line. This is not from subsequent editing. But can you explain to me, let me go down to the exemption section here. And I'll highlight what you had indicated in your declaration. Can you read this?
Yes. So this exemption M3E does not apply to a burner with a separate fuel line used to heat up or maintain temperature of a unit or incinerate air toxics, VOCs, or other combustible vapors in a gas stream moving past the burner flame.
So for this equipment we're looking at for the facility, is the burner being heated with a separate gas fuel line?
Yes, the burner uses a separate natural gas fuel line.
And was that blue arrow that?
Yes,
points
the
to
blue
where-
arrow into the unit's burner.
And given that the VOC effluent is coming in, it could be boxed out. Some of it is moving past that incineration point. Is it your understanding that this exemption doesn't apply as further specified in the staff report?
That's correct. The exemption wouldn't apply.
Okay, so now that we've gone through subdivision M, and thank you, board and respondent, for bearing with me. There's one other potential exemption, which is under Rule 1147, subdivision G, and let me pull that up. G. Okay. So is it your understanding that if a facility is able to demonstrate less than 1 pound of NOx per day averaged over a calendar month, that they would be exempt from the emissions limits under 1147D?
Yes, that's correct. If the unit is less than 1 pound per day of NOx, averaged over the calendar month, then they would be exempt, specifically D1 through D6 of the rule, which is the emission standards in Rule 1147.
And the rule specifies how a facility can meet this demonstration, correct?
Yes, that's correct.
And the first option, I'm looking here at G1A, is by the time meter, is to install a non-resettable totalizing time meter on the unit.
Yes.
And there's a calculation here for how to determine how they can stay below that 1 pound per day of NOx.
Yes.
And a second option is to install a totalizing fuel meter. Is that correct?
Yes, that's correct.
And that's under G1B, and there's a formula provided here.
Yes.
And is it your understanding as of this last weekend that they do have a totalizing fuel meter on their equipment?
Based on the response, they stated they have a totalizing fuel meter for their afterburner specifically.
Thank you. And using that information then, is it accurate to say that proposed condition number 14, which states that respondents shall limit the gas throughput to no less than 230,550 SCF per month, is to ensure that they comply with the less than 1 pound per day of NOx under 1147 G1B?
Yes, under that fuel, monthly fuel limit, that would be calculated NOx to be less than 1 pound per day averaged over the calendar month and would be exempt from the NOx and CO limits in the rule.
And proposed conditions 15 to 16 require that respondent submit the gas usage records from 2023 to present, and to continue to maintain those gas usage records so that the facility can demonstrate that they're below the 1 pound per day of NOx. Is that correct?
Yes, that's correct. Any exceedance in any 1 month would not get to meet that 1 pound per day exemption anymore.
And then what would happen if they do exceed that limit? Then would it be the case that the emissions limits under subdivision D would apply?
If they replace the burner and get a new burner, yes.
Or if they exceed the 230,550 SCF per month?
Yes, that's correct.
And proposed condition 17 provides for that circumstance. If that were to happen, then the facility would no longer would be exempt under the 1 pound per day of NOx. And the proposed condition would require them to either do a source test or to submit a permit application for replacement burner. Is that correct?
Yes, that's correct.
And is it your understanding then that proposed conditions, let me just go over to be comprehensive. Condition 18 then says that if those source tests doesn't demonstrate compliance with Rule 1147, then the facility would need to submit a permit application for replacement burner to meet that 1147 limit.
Yes, if they're over the 1 pound per day, they can either source test to meet, or they would have to source test to meet the 20 pounds ppm NOx and 1,000 CO.
CO as in carbon monoxide.
Carbon
correct?
monoxide.
Thank
Yes.
you. And so is it your understanding that proposed conditions 14 through 18 ensure compliance with Rule 1147 for this equipment?
Yes, it would.
I have no further questions for this witness for Rule 1147. Thank you.
So, Mr. Anders, do you have questions for this witness?
Yes. If Ms. Lee could go back to exhibits 3 and 4.
Do you mean for the declaration?
No, for that shows the afterburner burner,
Oh, yes, it's for the declaration.
Exxon burner. Okay, go to the next page. Okay, right there. Now, could you blow that up to show the diagram? Okay, now, if you look at the diagram, it shows that the effluent goes directly through that burner, and there's a restriction there. If you see there's like a metal plate or something in there. And so the combustion for this takes place directly in the burner. It is not outside the burner. That the effluent and the natural gas and the air, there's no additional air in this. So all the air for this combustion takes place in the burner, and that's supplied right directly in the burner. So if the destruction efficiency is initiated in the burner itself. Okay, if you would go to the next one.
Can I just interrupt?
Yes, sir.
You're supposed to be asking questions, not making a statement.
Okay.
So
ask
questions of the witness, and then you'll be able to state your case.
Got it. Thank you very
You may
much.
have questions for the witness. Too,
Okay. Okay. Is it, Mr. Stewart, is it clear that by this illustration, and you can also go back and look at the bullet point 3 in the previous one that indicates that the effluent goes directly to the burner. Is that not correct?
Yes, that's not correct. This illustration does not necessarily match the burner at the facility provided, the drawing provided by the respondent.
Okay. Would you go to the drawing? Okay, zoom out. Okay, this drawing is exactly, is it not, what is illustrated in the brochure? It shows exactly what's going on. It shows the effluent. Does it not go directly into the burner where the combustion takes place within the burner itself, pursuant with the gas mixing with the air? There's no additional air.
Okay, so you're testifying, sir, so I think we want it in question form.
All right. Does this not show exactly how that operates, and it illustrates how the effluent goes through there?
No, that's not correct. The respondent stated that there is a restriction on the burner, which we don't see the comparison between the illustration on the prior page. This is the burner drawing at the facility.
If you want to look at the prior page, you'll see very clearly that that restriction goes directly into the burner. It doesn't get mixed after the burner. It would never combust if it did, right? It has to be combusted in the burner itself, or it would not ignite.
That's not correct. The burner is a natural gas burner. It would have to heat up.
A natural gas burner has to have oxygen.
Sir, if you can just put it in the question
All right.
form to him.
Does a natural gas burner have to have oxygen to burn?
Yes, of course.
I rest my case.
As we
It
stated,
has to go through that burner to combust. Is that not correct?
Can you please repeat the question?
In a burner, does a natural gas burner, does it not have to have the mixing of air and in this case effluent directly in the burner for it to function and operate as a burner? Is that correct?
Every burner would need oxygen, but as I stated, it's a VOC stream moving past the burner flame and would not meet the exemption for Rule 1147.
Could you go back to previous page, please?
Are you referring to, can you specify?
The first page on the Maxon.
Okay.
And then look at bullet point 3. Can you read that?
Oh, can you see that?
So burners do not require an external combustion air source. All the oxygen for combustion comes from the oxygen content normally in most effluent air streams.
So is it not true that for that burner to work, it has to be mixed through those holes into the gas stream for it to function? That's how a burner works, is it not?
As we stated, there is some mixing in the unit's burner with oxygen. However, it is a VOC stream moving past the burner flame, and it is not mixed in the unit's burner as the Rule 1147 exemption, the staff report. It's not mixed in with natural gas.
Okay, I'm still at a loss because that purely states exactly what we have said. It is mixed in the burner itself. That's the function of the burner, that it doesn't require an additional combustion air. There is no combustion air, extra combustion air in this thing. Is that correct?
Yes, it's a forced draft process.
Right. So for the burner to work, would it not be necessary if the effluent went downstream of that burner, then it wouldn't combust? The combustion takes place, does it not, from that burner cone? Those, by the way, do you know what those holes are for in that burner?
Yes, for oxygen, for the flame.
If you look at burners and understand burner combustion systems, those are what called flame retention burners. They basically hold, there's a low pressure area and it holds the flame within the burner cone itself. And
Can I interfere here?
Yeah.
Based on the fact that not all of us are engineers, I'm a little bit familiar with natural gas combustion, and what I'm hearing is that this VOC stream is what is critical and different from what you're describing. And I'm seeing that there's two different animals here that you each are describing, and we have to determine what is really applicable here to the rule and whether you are compliant with the rule or exempt of the rule is what we need to understand. And that little bit of information is making it different in my interpretation. Is that correct?
Yes.
Okay. So that being said, sir, we have to comply with the rule the way that it is written. And if the way that it is written per the district, that's what you have to comply with. And what he is saying based on that VOC stream, that is not what you're describing.
what we're
Well, wait a minute, because we're just going in circles here.
Sure.
And what you need to get past is really not just the fact that you see it in a different way, but it's the district's rule. It's the AQMD's rule. It's not a rule that you're creating or even modifying. We have to go along with what is the rule.
And that's exactly what we're saying and contending.
But the engineers from the AQMD are not agreeing with it.
Well,
And they're the ones who created that rule.
we say that the rule is absolutely correct. Because by definition, the effluent goes directly into the burner, and that is part of how the combustion process is initiated, where the effluent and the air mixing into that burner, or it wouldn't work. I have been dealing with combustion systems for 40 some odd years. I've designed all sorts of engineering equipment. I'm very well aware of how a burner works. We've done with a company we worked with, we did research and we built our own burners. So there are certain criteria that have to be established as to how a burner will work. This burner was specifically designed to have the effluent and the air mixed inside that burner so that it would function properly to be able to combust and allow the destruction efficiency. This burner information here, the diagram, it's consistent with the diagram that was done by the engineering company that built the thing in the first place. So there's no definition. I mean, there's no disagreement as to the intent and how that burner is supposed to work. And the fact that it is mixed in the burner, not downstream of the burner. Most afterburners, you'll have a combustion air blower and a combustion system that modulates air and gas to maintain a ratio. The effluent is then introduced downstream of that. This is not the case. The effluent is directly into that burner. So that's where we're not contending that the rule is incorrect. We're contending that the application or the understanding of the fact that it is going directly into the burner.
Okay, but let me just clarify. So you are saying that you should be exempt.
Absolutely.
Okay, I'm going to defer to, we have an engineer on our board here, Mr. Bellicapal. Can you?
We need to go through the process.
Well, I understand that, but
I don't want to jump
we
in.
need to really figure out here.
I do think I need to ask questions of the engineer and then ask questions of the petitioner.
Okay, we can do that.
So I don't want to.
Yeah, but I don't want to be going back and forth here. Not you, but
Yeah.
between the two of them, because we have to apply the rule the way the rule is written. And it's written by the district. So what I want to hear is, and maybe from the district, why this person is thinking that they are exempt. That's the whole question here. And we have to figure that out. And I agree with Mr. Bellicaplan. There's a lot of, for us, unknowns. And to be able to understand mechanically and through the eyes of an engineer, really, are they exempt or are they not exempt on this? It's for us to apply and to make a decision. So that being said, do you have any more questions, or questions, not statements, that you want to ask of this engineer?
I think that we have stated the exemption consideration accurately and honestly. And it complies with the exemption and the rule. So I think I don't see that there's a disagreement between our contention and the rule language.
Okay, all right. So do you have any more questions for this witness?
Not at this time.
Thank you. Okay, board members.
Oh, excuse me, Madam Chair,
Yes.
the gentleman said not at this time. So is he reserving his right to cross-examine subsequently?
Perhaps if necessary.
Thank you.
Thank you. Okay. Mr. Perrin, you want to go first?
I just have a couple of questions. So if I understand the district's position in their proposed conditions, you're still leaving open the possibility of Flex Firm to have the exemption under 1147G, correct? They still have the chance to prove they're exempt by that rule, correct?
Correct.
And if it turns out they don't satisfy that rule, then presumably afterburner they have now would not be in compliance, and the only solution would be to submit a replacement burner that meets the rule, correct?
Yes, or source test the current burner to meet the limits.
But it said if it doesn't meet it,
Yes, if it doesn't meet the 20 ppm NOx and 1,000 CO, then
not exempt.
they would need to
Well,
submit a permit application.
And just so, is the 230,550 standard cubic feet per month somehow equivalent to a pound a month? Or what's the basis for that number?
It's the fuel usage through the natural gas burner, which limits the unit to less than 1 pound per day of NOx emissions.
Okay, so that's been engineeringly calculated, that
Yes.
works. All right. Nothing further, thank you.
Thank you. Mr. Balagopalan?
Morning, Mr. Stewart. Actually, before I get to the burners, and so, do you know approximately what are they using? Are they above that usage limit, so they're not exempt? Do you know?
I don't have that information.
You don't have
They've
it,
only
okay.
provided
All right.
up to.
All right, and let's look at this burner as Ms. Lee, could you go to the next page, please? The one with the arrows. Oh, yes, this one. Now, the natural gas inlet, I mean, there's no provision there to feed the gas into that inlet. It's strictly for natural gas only.
Correct. There's no mixing with
No
the
mixing
VOC
there.
in that line.
So the mixing is occurring. Now, where's the flame, do you know?
It would be in the cone section of the burner.
The code, okay.
There's a primary and a secondary cone that you can see right there.
Right. So there's a pilot that lights it, and then now for it to burn, you need the effluent gas, correct? Because there's no, the effluent gas is providing the oxygen for the combustion.
Yes, for the oxygen, yes.
For the oxygen, so that's where the combustion is taking place, right? Where the inlet, where the effluent gas is coming, because it's got the necessary, the oxygen to combust. So let me back up. Have you been to the facility?
I have not. No.
You have not. Okay, so you have not seen this in operation. Okay. I think Mr. Andrews' point is that the combustion is taking place prior to, the way it's designed. Well, let me back up a little bit. Have you seen other types of incineration device, afterburners?
Yes, I have.
Okay, and do they work differently, where the air is fed in with the combustion blower and so forth, or have you seen something similar to this?
Not on.
No, okay. So, Ms. Lee, I'm sorry, can you go back to the burner with the cone and all that? Just one more. So here you have the gas coming in, and do you mind going there and just showing the board where the gas, in your opinion, comes in, the effluent gas, and where the combustion is taking place? Oh yeah, you can do it. Yeah.
Okay, so the natural gas would be coming into the unit's burner from the back.
Right.
Through the natural gas fuel line, and then gets piloted, and here would be the burner flame.
And where is the effluent gas coming?
Effluent
mixing?
gas is outside of this unit from a separate stream.
Right, and then it's mixing in there.
There would be some mixing in the burner. However, by the diagram provided by the respondent, there would be bypass and would not meet that exemption in the rule.
Okay, let's go to that drawing. But you're saying that. So can you point out where you're saying where's are you saying that most of the combustion doesn't occur here and occurs further downstream?
No, I'm saying the combustion of the VOCs, the stream.
Right. So where does
passing the burner flame?
Okay. Where do they start burning? When do they start burning?
The burner flame would be, it would start burning here.
over
with
there,
the
right?
initiation of the natural gas.
Okay. And then it, then got the three T's of combustion: the time, the temperature, and the turbulence ensures destruction. Correct? Okay. All right. So you understand the point that Mr. Andres is making, and you disagree, right?
Correct.
And that's the position the district is taking.
Yes.
And you've consulted with other experts at the agency,
Yes, I have.
and they agree with what you're saying.
Yes.
Okay. All right. I got no further questions.
Mr. Pearman.
Yeah, one more question. So just where that arrow pointing down, the vertical one, and it reaches, I guess, right there, is that a physical barrier? Is that the cone, or what exactly is that, those double lines there at the bottom tip of that arrow? if you-
That's just a support structure. Oh, I'm sorry.
I don't have that information.
Well, your statement is that
Those box.
the VOC passes by, so. And I thought you were saying that it came from where those red arrows are external to the burner. So explain to me a little bit more about if that is a physical barrier, that would make sense. If it's not, then doesn't that mean it goes into the burner at that point?
To my understanding, it was a solid barrier. However, as you can see on the sides of the burner, there would be a passing VOC stream on the sides of the wall of the combustion unit.
So you're saying it is a physical barrier? So I just asked you.
No, I said I don't have that information.
Well,
But based on the drawing, but based on the exhibit 3, the drawing of the burner, it was, to my knowledge, a solid barrier.
okay, so based on that drawing, then that double line would seem to be a physical barrier, a solid barrier.
Yes,
And so therefore the VOC, you're saying it passes through, it might get in there, but most of it will go around the burner at that point, is what you're saying.
I'm saying it. Yes, it's a VOC stream passing the burner flame.
And
There is
clearly-
some mixing at incineration.
And clearly there's no separate VOC in it like there's the natural gas line.
Yes, there's no VOC stream mixing with the natural gas into the unit's burner.
All right, thank you for the clarification.
Can I follow up, Madam Chair?
Well, let's, Mr. Ali.
Oh, okay. So, and I think you mentioned it's a box, so, and it seems like it's a barrier in your understanding, it's a barrier, it's a box surrounding it. So so even though the arrow is showing it going there and sort of mixing, but you're saying it's a box basically, and not maybe something, a structural to hold that burner in place. So that and then it does allow those effluent to come in and mix. So you're saying it's so if it can be demonstrated or proven that it's really not a box, that is really a structural thing that holds the burner to the wall, would your opinion change?
No, our stance would be still that it can bypass the burner flame. It's not mixing in the burner as the exemption states.
Why inject it there then? Why not inject it further downstream if that's the case?
The VOCs,
Yeah, the effluent. Why do you inject it there if that's the case? Inject it even, downstream.
for better destruction efficiency of the VOCs.
All right. Okay, I got no further questions.
Yeah, Madam Chair, just a question of the gentleman. There's no way to get a camera image on this, is that correct?
Not to my knowledge.
Is this visible? If you were to visit the facility, would you be able to see this?
I don't believe so, no.
So it's in a compartment somewhere that's
Correct.
hidden. The respondent provided some comments associated with this. What is the name of the device? This Maxim device. Let's go back, a Maxim device here. Have you ever seen one of these up close and personal, not installed?
I have not seen one not installed.
Have you you ever had with this type of burner installed? Have you ever dealt with this other issue anywhere else in the basin?
Like as it's installed?
Well, let me clarify. Is this unique to the basin? Are there other companies utilizing this device?
I don't have that information.
So just one more time, you've never seen one of these uninstalled?
Correct, I have not.
Thank you.
Okay, have any of the engineers seen this? In other words, is it that unique that this gentleman has a patent on it, that you've never seen anything like this? Or does the engineering department have common knowledge of a device like this? Because the way that you're answering the questions is the district has never seen this and then doesn't understand how it operates.
We have seen burners
Like this,
like this.
then this setup,
I specifically have not seen.
but
burner
within
in this setup.
okay, is there an engineer that is here that has seen this type of setup? Ms. Lee, of your staff that you have here?
I'd just like to clarify. So the board is asking for this, what I have up here, this setup?
Yes, because what we're hearing is that it's so unique that the district has not seen it. That's what we're hearing.
Okay.
Madam Chair, can we take a recess perhaps? so that
I was gonna
they
call
can
for lunch.
caucus?
So I was gonna call for lunch if we can just get this little thing resolved.
I think part of I can have another engineering witness come up if the board would like, but typically for these applications, it comes in through diagrams. The applications come in through these types of images, which were provided by the facility. My understanding as well, Mr. Stewart was talking about a restriction that was there that didn't match the manufacturers, and I'll go back to that. I don't know if it was clear, but this profile plate installed by customer here, which we don't see in this diagram provided by the facility. And based on these diagrams, the engineering staff has concluded that there is concerns of VO stream moving past. There's no contest that there's some mixing as required for the burner, but for the plain language of 1147, that the mixing happened at or prior to the incineration point and under the staff report, which we provided, its staff's contention that the exemption doesn't apply. But if you'd like another witness, I'm happy to maybe take a break and figure out.
I'm sorry. Why don't we do this? Because it's getting close to the lunch hour, and take a 45-minute lunch. If there is any way that the two parties can discuss this and come to some conclusion, because what we're hearing is we're just going back and forth on, and it's like an agreement to disagree, but that doesn't help us make a decision. So if during the lunch hour or 45-minute period, if you can do that, that would be most helpful. Mr. Ali, did you have
Yeah,
any
I just
other
had one
comment?
last question. Ms. Lee, by any chance, could they have provided a diagram that just did not show the plate?
You mean the diagram I'm showing here that
Right.
isn't representative
Right.
of what's
So
at their,
if you
yeah.
scroll up, if you scroll back up to where you stated this, go right here, right here.
Yes.
Go drop down. You said that there's this profile plate, right? This plate here. And so there was an assumption made because we didn't see the plate on the drawing. The plate does not exist. But did anybody ever ask the respondent if in fact they installed it per the circular Encino Pack graph, this cross-sectional view. Did anybody ever ask these folks that prior to arriving here today?
We, without testifying, I would just say that we have discussed 1147 and explained the staff's contention. I was pointing out that that was one of the things that Mr. Stewart had brought up that wasn't matching in terms of what the manufacturer's specifications were and this diagram. But it's staff's contention that there's still a VOC stream moving past. And we have tried, we've worked over the weekend to try to reach stipulation as to that, but it's something we don't agree on, but we'll take the 45 minutes to see if we can come to agreement. But yes, we have discussed, we did not ask specifically about the profile plate.
Okay.
Yeah.
And that's what I wanted to know.
Okay.
Did we ask specifically about the profile plate? So I guess my concern, and I want to say this for the record, we started the meeting 30 minutes late under the prevailing belief that there was an agreement reached. And now we're well into 11:45, it'll be 12:15, et cetera. And we still have not come any closer to bringing forth a measure of clarity. Completely confused as to what's going on here. And it doesn't take anybody to have a degree in engineering to understand. Perhaps a small discussion could have occurred, and we could have arrived to a conclusion with respect to this matter. Very disappointed on behalf of the public.
Okay.
And Chair, while they're discussing, you would look at the circular for the burner and the principle of operation. I think you can use that as a basis to actually have your discussion, because that clearly explains how it works actually. So maybe during your discussion, you can go through what the manufacturer Maxon said is how it operates, and use that, discuss as for your discussion. See if you can come to a consensus.
Dr. Abraham.
Okay, so Ms. Lee, you had shown that diagram, not their diagram, but the one above it. So I'm not sure if we can all look at that really quickly. So does that comply with Rule 1147 as it was projected there?
Which diagram are you looking at? That
The
one?
one below
Are you
it,
referring to, this one here?
this one here.
Still, our stance would be that it would be a VOC stream moving past the burner flame. We would have to get the exact specifications from the respondent on where the profile plate is placed, if there is one.
Okay.
To make that determination of if it's combusting VOC at incineration, not after or a stream moving past.
All right, so you can take that time to figure that out for us. Anything else before we break?
12:30? It's
Yes,
12:42 now,
yes.
45 minutes.
Yes. Come back at 12:30. We're off the record.
Oh, wow, we're getting a.
Day, are you ready?
Yes, Madam Chair, I'm ready.
Please start the recording. Okay, thank you very much, everybody. Was there any conclusion? Was there any agreement? Let us know what occurred.
Should I? Okay. Uh, so we were able to reach stipulation, and I'll have Tony confirm. I had verbal confirmation on all of the conditions at this point, all of the proposed conditions marked Exhibit 5 with one change, or I would say two changes, to condition 15 to allow the facility more time to provide those records, replacing within 14 days of this order with by July 3rd. I know we said July 4th, but since the conditions say the 3rd of each month, that gives you a couple extra days. July 3rd, 2024, respondent shall submit. And then for condition 16, replacing June 3rd, 2024 at the end of that sentence with July 3rd, 2024. And Tony, if you can please confirm that that was our agreement.
That's correct. We confirm. Okay, sure.
Replacing within 14 days of this order with by July 3rd, 2024. Thank you. And no other changes. And the facility has also stipulated to condition 19. So all conditions have been stipulated to. As such, we, under hearing board rule 806B, this hearing board does not need to make a finding of violation for rule 1147, and we would reserve any other questions regarding that rule to the board.
Yes, we do.
Were you able to capture all of that?
Yeah.
Yes, that's correct. So the purpose of the declaration was to try to streamline today's hearing. Mr. Stewart's declaration lays out the applicable updates regarding Rule 1128 and the permits that were required, which, as you've just heard, the facility has stipulated to those conditions. So I'll leave it to the board if they have any additional questions based on the declaration or the other rules.
Before I let the board ask questions.
No, I do not at this
Thank you.
point.
Okay,
Thank you.
any questions from Mr. Balagopuan?
Yes, Sister, and I'll go to your declaration. I think that a little confused on the permitting, what applications and so forth, but let me take, there are three issues, I think 1147, which we discussed, then 1128, the test report shows the afterburner didn't function properly as opposed to 95%, correct? And it's actually, the numbers shows that it's dismal, 75%, in your opinion. Okay, let me ask a question. One of the orders said they have to repair any, I forget which condition, to do any repair, patch any holes. I know you haven't been to the facility, but we heard at the last hearing there's been holes and there was patching up, and I saw in the what do you call, the petition, also there was invoicing that's still patching up holes. have you, what is the situation there with that hole and with how bad a condition is the afterburner and, you know, and let me ask you that if you know.
At the source test, I'm just aware that the collection efficiency passed. However, just for the secondary test, we wrote that condition to verify to patch any leaks or for that test.
Right, okay.
And sorry, we will have another witness from our
Witness too. Okay,
compliance
on that-
department who
on
might
that
be able to
issue.
answer
Okay.
that better.
So now, we heard in the opening statement, Mr. Andrews said they may replace it if they don't pass the test with a carbon absorption system, correct?
Correct.
And to meet the efficiency requirement. Okay, and you think that would be an alternative to controlling the VOCs?
Yes, that could be an alternative for 1128 compliance.
Now they have continued to get nuisance complaints. You know, do you know why this? And I know the inspector may touch base on that, but they're just asking if you know why they're continuing to get nuisance complaints.
Yeah, I can't comment on that.
Okay, all right. So then coming to the permit, the description that you gave me, I was a little confused. What was taking place and where, you know, I had to go back and write down everything. And it looks like there was a change of ownership sometime 2017, 2018, and there was transfer of the permits from the old owner to the new.
Yes.
And then what happened there? One of the permits didn't get updated correctly. Is that correct?
That's correct. So they have the non-VOC oven and the VOC oven and afterburner line. Both of those permits showed the VOC oven and afterburner during that change of ownership time. So one is incorrect.
So then you made a statement in your declaration that you went and revised that permit.
Yes, permit G52680, which was submitted.
Yeah, so that has been reissued, or is it you revised it and reissued it, and then what happened after
that? Has been revised to the G75719. That was strictly to revert it back to its prior permit, the non-VOC.
And then you issued a new one to reflect that change. Is that what you're saying? Because then the latest one, G57, what was that? Hang on a second. No, 52608 is the one that was revised, right, to reflect the correct one.
Correct.
And then you had an application that you issued just bear with me a second, I had okay, here. The one you issued, G575719, right?
Yes.
That's reflecting the same as G52680?
Yes, so that G52680 was the admin change. It is now G75719.
Now, and then what further do you want them to do on that particular application? The new one, G5575719.
So that one, we would like to add the correct emission limitations and rules applicability on that permit condition or permit.
And I'm confused why couldn't you do it at the G52680?
Right. So I specifically requested a change of condition applications from the applicant, and they submitted an admin change.
Right.
So using that admin change, it was only to revert it back to its prior state. So there's still updates that needs to be done.
Then, okay, all right, okay, that makes sense. So nobody caught that error since 2018, that there were two permits that were identical until just when you caught it, basically.
Yeah, before the first hearing, yes.
Okay. All right. So that's a permit. And I think I'll ask Mr. Andrews what exactly you agreed on 1147, but I have no further questions. Thank you, Mr. Stewart.
Thank you, Mr. Balagopan. Any other questions from board members? Okay, Ms. Lee, you can go to your next witness.
Okay, I'll hand it over now to my colleague.
Sure. Give me 1 second.
Thank you, Mr. Stewart.
I'd like to call Air Quality Inspector Adam Martinez. That's our next witness. Good afternoon, Mr. Martinez. Can you please state and spell your name for the record?
My name is Adam Martinez, ADAMMARTINEZ.
And just quickly, did you take the oath this morning?
Yes, I did.
What is your position here at the district?
I'm an air quality inspector too.
And are you familiar with the facility, respondent's facility, Flex Firm Holdings?
Yes, I am.
And how are you familiar? Have you conducted inspections or responded to odor complaints at the facility?
I've done both.
Done both. Okay. So I'm going to break up these questions into a couple of groups. First, generally, I want to talk about your familiarity with Flex Firm and the enforcement related issues involving the facility. Do you recall about how many NOVs or notice of violation tickets you've issued to Flex Firm? And this is before the July OA and after the July OA, just a general number.
7 in total, 3 before, 4 after.
3 before, 4 after. Okay. Would it be fair to say that the bulk of the tickets were for a violation of Rule 402?
Yes.
And can you tell us just briefly what Rule 402 is? I know we've gone over it, but just for the sake of anyone listening.
It's a public nuisance violation. It's issued when 6 or more unique complaints. When I verify 6 or more unique complaints and I determine the source of the odors.
So can I ask you, and this may overlap with what you just said, but when you receive an odor complaint, how do you verify them?
First, I contact the complainant, ask if the odors are still occurring, and then I meet with the complainant, and if I can physically detect an odor myself using my nose, I'll ask them if that's the same odor that they've reported. If they say yes, I'll run them through a rating system that AQMD has, the scale of 0 to 5. It's just an approximation. It doesn't, 5 is not worth more than 1. It's just what they base it off of personally. And then I conduct downwind and upwind surveillance of what the alleged source would be. And if there is no upwind, but there is downwind, then I make a determination of what the source would be.
So I'm not going to go through each notice of violation because those were covered in the prior OA hearing, and there was also discussion of verification of odors. So if there are questions about that, I'll leave it to the board. But I do want to go over the nuisance NOVs that have been issued since July 25th, 2023. So that was the last OA hearing. So I have copies of them. I think I will bring them up to Rosalinda right now.
I can also bring it up on the screen if you have the
That would be
numbers.
helpful.
Sure. Oh,
So we're waiting for hard copies? Okay, you can't put it up on the screen, Miss Lee?
If you're here with the copy on the screen, I'll just run through these briefly. So do you recall how many times you've visited the facility and issued a notice of violation, both since the last OA? Basically, how many NOVs have you issued since the last OA?
I've issued 4, three of which for public nuisance.
So let's start with the first one, NOV P78026. and I'll give Miss Lee a second. Thank you for doing that. No.
Okay, so there's the pink copy that I issue.
Do you recall? So let me back up a little. Sorry. So you recall in mid-October, maybe October 11th, being called to the facility in response to odor complaints.
Yes.
And do you recall about how many verified complaints you received that day?
So for that one, it was 6, which is the threshold for issuance of violation.
And did you yourself detect any odors that day?
Yes, I did.
Do you remember what the odor was that day that you detected?
So that day, it's a mixture of plastic and burning rubber. I'm not sure if anyone's accidentally lit a plastic bag on fire, but that melting plastic bag, that's kind of what it smelled like.
And using that upwind downwind surveillance method that you discussed a moment ago, were you able to confirm that the odors were coming from Flex Firm that day?
I determined that they were based on upwind and downwind surveillance.
Okay. Did you meet with anyone from the facility that day?
Yeah, the facility contact is generally Mr. Castillo.
Okay. And do you recall if Mr. Castillo said what the facility was processing at that time?
Yeah, he let me take a picture of their usage logs. They were operating neoprene that day.
Okay. So you issued the NOV. Okay. I won't ask any more questions on that specific one. Can we move on to NOV P78027? And I'm just trying to show a pattern here, so bear with me. I will talk quickly. Oh, wait a second. Sorry, Jeff. Okay, so does this look like a true and correct copy of NOV P78027?
Yes.
And do you recall about a week after the NOV that we just spoke about, you were called again to the facility in response to odor complaints?
Yes.
Do you recall how many verified complaints there were?
Again, 6 verified complaints.
Did you detect any odor? And if so, what was the odor that you detected?
I did, and it was that same burning rubber plastic smell.
And were you able to speak with Mr. Castillo that day?
Yes, I did, and yes, I did.
And did he happen to mention what the facility was processing at that time?
Yeah, I was able to take another picture of usage logs, and again, neoprene was being processed that day.
And just to be clear, you were able to confirm that the odor was coming from Flex Firm?
Yes, with upwind and downwind surveillance.
Okay, one last odor nuisance NOV, NOV P78042. So does that look like a true and correct copy of NOV P78042 that you issued to Flex Firm?
Yes.
And again, so this is was this NOV issued in response to complaints received in mid-February of this year, 2024?
Yes, it was.
And again, how many verified complaints?
6.
Did you detect any odors? And if so, what odors?
I did. This time it wasn't as much a burning, it was more of a plastic smell. The only way I could describe it is if anyone's ever smelled like a brand new, like a plastic pool toy or something that's been kind of baking in the sun, just a very strong plastic smell.
And were you able to speak with Mr. Castillo that day?
I was.
Did he confirm what the facility was processing at that time?
So that day it was using a low fusion base.
And you were able, again, to confirm that those odors were coming from Flex Firm?
Yeah, upwind and downwind surveillance.
Excuse me, when you do name odor, if you can just describe it a little bit better for us, like you did on that first one.
Oh, okay. Yeah, so this time around it's much more plastic smelling. Like I said, if you would have smelled like a pool toy, or that's kind of the only thing I could think of that I can remember smelling like that, or like an air mattress, something that it's brand new. You open up the package and you have that new plastic package smell, just a very intense plastic odor.
Okay. So you've spoken to a number of complainants when issuing these NOVs, is that correct?
Yes.
And were there any did they use any specific terms to describe the smells themselves?
Mostly that it's a burning chemical-like odor. Some of them have reported physical reactions to it, shortness of breath, trouble breathing, headaches, nausea.
Okay. And let's expand just a little bit. Those 3 visits for those 3 nuisance NOVs, those aren't the only times that you've been to the facility in response to an odor complaint, was it?
No.
About how many times have you personally been to the facility since the OA was issued last July in response to odor complaints? Just an approximation.
I would say maybe once a week, maybe every other week, 20 times.
Okay. Let me see. I want to skip ahead for a second, just to confirm. Are you the primary inspector that's assigned to Flex Firm?
Yeah, it's within my sector, yes.
It's within your sector, but are there instances where sometimes you can't go to the facility to respond to an odor complaint?
If I'm on assignment with another facility, or if it occurs on a Monday, or if I am not on duty that day, then it would be redistributed to someone else.
Okay, so it's fair to say that you are not the only inspector responding to each and every instance of an odor complaint.
No, I'm the primary, but there are other ones involved.
So is it also fair to say that there have been more than 3 nuisance NOVs issued to the facility since the last OA?
I believe so, yes.
Do you by any chance recall how many additional NOVs have been issued, if you can recall?
I believe it's 4 additional.
Okay, if I said 5, that
would be, yeah.
And those NOVs would have been issued by other inspectors responding to odor complaints, correct?
Yes.
And they would have verified the odors in the same way that you've described.
It's a standardized system, yes.
Okay. Do you have an estimate or recall just how many odor complaints in general have been issued against Flex Firm, let's say this year or since the issuance of the last OA?
To me, or?
No, just general odor complaints that have been made. Do you have an idea about that number? They don't have to have resulted in an NOV, but do you have just kind of?
I would say close to 500.
Okay.
I know personally I've had 315.
Okay, thank you. Let me see. Now I want to talk about lastly the final NOV that was issued on March 29, 2024. Let me pull it up.
P78047.
P78047. Wait a minute. So, Mr. Martinez, does this look like a true and correct copy of NOV, the NOV that you issued in August of
March.
Sorry, March of 2024?
Yes, it does.
Okay, thank you. And you attended the OA hearing in July of 2023, is that correct?
Yes, it did.
So are you roughly familiar with the conditions of the original OA that was issued by this hearing board?
Yes.
Do you remember what this specific ticket was issued for? And we can kind of go one by one. Let's start at the top. So it looks like the first entry is a violation of order for abatement condition number 5.
Yeah, yes, it is.
Okay, can you talk about why you issued that specific violation?
Condition 5 was to submit a permit plan modification by August 31st, 2023. I believe that was submitted late.
Okay. And then there is a violation of order for abatement condition number 2. Do you recall what that was issued for?
Yes, that condition was to submit a source or to conduct a source test by October 16th.
And do you recall if FlexFirm conducted that source test by October 16th?
No, they did not.
Do you recall about when they did?
There was an attempt to conduct a source test on October 26th.
Okay.
And there was another successful attempt on November 10th.
November 10th. Okay. Let's move on. A violation for order of abatement condition 4. Again, do you recall what this was issued for?
They were to submit a compliance plan, if they received a failed test, they had 30 days to submit a compliance plan, and they failed to do so.
Did they eventually submit a compliance plan?
Yes, they did.
Do you recall about when?
I believe it was a day late.
A day late. Okay. So let me see. It's so hard to read. Can you talk about the 203B violation of condition 3 and why that particular violation was referenced here?
Condition 3 states total quantity of coatings and solvents used in this equipment must not exceed 68 gallons in one day. After a compliance inspection conducted earlier that month in March, usage logs showed that that limit is exceeded frequently.
Like about how frequently?
I would say once a week.
Okay. And lastly, there is a violation of 1128D2. Can you expand on that?
That's for capture control devices that they have to operate of at least 95% destruction efficiency for air pollution control devices.
So this was in relation to the source test.
The source testing showing that it was operating below 95%.
Okay. You know what? I think that's all I have for now. I will turn this witness over to the
Okay, before
respondents.
we do that, we're going to be marking these together as exhibit number 8, which will also be entered into evidence. And if I can request on behalf of the clerks that all of the documents that you are going to present to us, if they can be ready and to go, because they've got a lot on their plate as well.
Of course.
Okay, Mr. Anders, you want to ask questions of this witness?
Just out of curiosity, how are you trained to determine burning, burning plastics or whatever?
We don't have any formal training. It's just I guess it would be a differentiation between that and background odor, which would just be considered non-burning.
So if they don't burn anything, which they don't, how does that relevant?
I guess, so you're asking if I can determine what the smell is as opposed to non-burning?
Yes, primarily because it was, you had indicated it was, you smelled burning plastics.
Okay. Well, it's mostly to determine a source, and there's not really anything else in that area that could be creating something of burning plastic except for an afterburner that's handling plastisols. So I think that's, we're ruling that it's coming from the afterburner.
You have been to the facility on a number of occasions where you've had odor complaints and my equipment wasn't operational. Was that true?
That is true, yes.
And in those days, what have they described the smell as?
Generally the same thing, a burning plastic odor.
So if my unit is not operational and I'm not producing anything that day, could there be potentially other sources of the same smell that you're describing?
There is a potential, but again, violations aren't issued on days that we can't determine the exact source.
Yes, so if we're producing and you have the same smell, how do you differentiate it from the days when we're not producing?
If there is an odor, but you're not producing,
Yeah, how do you differentiate whether it's the same one that you're smelling when we are producing?
if you're not producing, I'll generally put source unknown. I won't attribute it to you.
Yes, let me ask you a different question, different way. So when we're producing, you get the same smell, or the complainants describe the same smell as when we are not producing. How do you determine that that is coming from us when we are producing?
About up, when and down. I mean, so this hypothetical situation would be I show up, I determine that there is an odor occurring, but when I come to you, you say that you're not on at all. I'm not sure if that's the reality of things. There have been times when the lines have been in a process of cooling down, or they're not running at the time that I meet. But there's often a downtime between a complaint coming in and me showing up, because if I'm working from my teleworking, I'm still a half hour away. That's not determining the other. I could be on an assignment, an inspection, or something else. There's a frequent,
But
the time between a complaint coming in and me coming to visualize,
yes,
it could have already shut down.
generally when you and other inspectors come in, do I not ask when the initial complaint was initially?
Yeah, I'll let you be privy to
And
that, yeah.
then I generally tell you whether or not we're producing at that time. Do I not?
That's true, yeah.
So, and one of the comment question is, it seems like a lot of the complaints come from the same side of the business, which is I would say on the east side. And to my knowledge, the wind blows every other direction as well throughout the course of the day. Have you ever had complaints on any other side?
Not formally, no, but the winds are predominantly southwestern.
Right, no further comment.
Does that complete your question?
Yes, no further questions.
All right. I do have a question, and I may have asked this at the other hearing, but what is the proximity of this facility to residential, any other sensitive receptors like schools, nurseries, schools, hospitals, daycare centers? Do you happen to know?
I know that there is a school south of them. I would say that they're maybe half a mile away, maybe
Okay,
less than that.
okay.
It's predominantly businesses in that area.
It's an industrial
It's
park
an
type of-
industrial area.
okay.
Yeah, there are residences on the other
Mhm.
street, but again,
But the
a
school
quarter
is
mile away.
the school's about half.
About half a mile away.
Okay, thank you. Any other questions? Mr. Pearman?
If you know from the complaints, are they coming from businesses, from the school, from homeowners in the area? Any idea?
Neighboring businesses.
For example, what type of business are they? Just commercial, any other industrial uses, would you say?
Warehousing.
So have you able to determine that the odors you detect intensify the closer you get to the subject's property or not?
Yes.
So is that one factor that leads you to think the source might be that?
Proximity, intensity to proximity, yes. The way that the afterburner is oriented, you can get pretty close. But yeah, it's not generally not a guess. You can stand right next to it and smell it.
So you've stood next to the afterburner.
Yeah, the way that the property is, you can stand pretty close to it.
But standing that close, you can't see all the detail from the pictures we saw.
It's it's fully enclosed, unfortunately. Yeah, so you can look at the outside.
All right, and I noticed there was a gap in at least the NOVs from October 18 to January 22. Any special reason you can think of why there was that gap? I'm looking at page 4 of the petition, paragraph 18, which lists the 7 NOVs at that time since the last hearing.
I can't give a particular reason. No particular reason why. Could be production scheduling differences. One facility is operating, the other's not.
All right, thanks.
Mr. Bellico-Paul.
Yes, thank you, Madam Chair. So after Mr. Martinez, I think at the last hearing you testified there were holes, in the ductwork. Did you document those? Did you take any photographs?
I did. That was for the first NOV I issued to them for visible emissions.
Was visible emission from which line was that? The VOC line or the non-VOC line?
The afterburners will be the VOC line.
VOC line, okay. And then you could see holes in the afterburner ducting?
There was one, yes.
There was one. And then in this visits you made this year, are there still areas where there's holes and that needs to be patched up?
There have been sealant applied, and visible emissions haven't been confirmed since then.
Okay.
But no visible emissions since then.
And you said you saw the afterburner. Did you go inside the plant or were you outside?
I've been inside. The afterburner is located on the outside of the warehouse.
On the outside. Can you roughly tell the age, or you don't know? Is it a very, what's the condition of the afterburner and all the ducting?
It's pretty weathered. It's aging to it.
And does it look like it's been patched up with quite a bit?
It does. Some of the panels you can tell have been replaced, and there's the sealant that's used is a bright red, so you can see where it's been.
Did you have any documentary evidence of that, or?
I take pictures every time I go. It could make a rough. I guess you could make a visualization of the repairs over the time.
Okay. And maybe next hearing, when we have a status update, if there is still ongoing auto complaints, you can share that with us, the documentary evidence. Now, let me, when you go in, I think you receive the complaints, you go to the site and you talk to Mr. Sorry, your name escapes me, but anyway, you talk to, do you go observe, is it mostly the VOC line or the non-VOC line?
It's predominantly the VOC line.
Now, the neoprene, is that on the VOC line?
Yes.
That they do that?
Yeah, neoprene is VOC containing, so it can only be processed on VOC line.
Okay. The neoprene is, it's like a rubber material, isn't it?
Yeah, it's applied as a liquid.
So they're applying that, or they're applying on that?
They're applying it with a ladle onto a roller that's then rolling it out.
On the neoprene material?
Yes.
And this VOC material that they're
Yes.
applying. And so then the odors is because the afterburner is not, where are you getting the odors from?
That part I'm not sure.
Okay.
Because like Mr. Castillo stated, sometimes the other line will be running and we'll still get odor complaints. Sometimes the afterburner will be off or cooling down, we'll get odor complaints. It's kind of hard to determine exactly at what point in production is creating odors.
And do you check on the afterburners when they're running to see their?
I'll confirm whether or not it's operating, because there is a minimum that it has to be operating at. It has been operating above the minimum since I believe the second NOV I issued was for afterburner temperature. They've
been okay.
They've made sure that's okay. But yeah, I always confirm whether or not it's operating.
And I think we heard from Mr. Stewart's declaration that the permits were, one of the two permits were identical for a long time, 2018. You were not the inspector at that time, I take. No.
In 2018, no.
No, I'm surprised that nobody picked up on it, and so they were operating a different equipment than what was described on the permit, correct?
Yes.
Okay. Now, as far as record keeping, I think some of the I think one of the exhibits, it shows plastosols typically don't have VOC, but why did it show VOC content in one of the product? Do you know?
That's based on a master list provided by the facility. But as far as I wouldn't know.
I think it was in Mr. Declaration of, if I'm not mistaken.
I can pull that up also.
Yeah, I'm just wondering, have you taken samples yourself given to the lab to analyze, to verify?
I don't believe so.
You don't think, okay. So there were two products that VOC has applied was for plastisol, which are kind of surprising, 240 grams per liter, 105 grams per liter. So you don't know the K-base and the SCID, what looks like they applied that. And that will be on the non-VOC line, right?
If it's VOC containing, it can only be processed on the VOC line.
Right. I mean, okay. So they may have plastisol that are VOC containing. Is that your understanding?
It's possible.
Possible. Okay. All right. Now, there's been ongoing complaints. What are the actions have they told you they're taking to reduce or to mitigate the odor complaints? It seems to be ongoing, on a frequent basis.
Yes. Replacing the heat exchanger, replacing panels, sealing, and then the most frequent talk of installation of a charcoal filter to mitigate odors.
I mean, that's for replacement for the afterburner if the test doesn't meet the efficiency, right? Now, there is a control system for the non-VOC line.
Yes.
Have you inspected that?
Yes.
I think the last time I heard, nobody checked whether the carbon absorber had been replaced, whether the ESP is working properly. Have you verified that the carbon has been, there's a frequency for replacing the carbon? There's some operating parameters for the ESPs?
We asked for maintenance records and they displayed that it's cleaned quarterly or serviced quarterly.
Okay.
And I can add to they switched from neoprene. The neoprene was water-based. They attempted to switch to water-based neoprene, hoping that it would mitigate odors, but it still resulted in odor complaints. I believe one of the NOVs was issued while water-based neoprene was being processed. So there was an effort to switch products to hopefully mitigate odors, but it didn't succeed.
You saw the results of the source tests that showed that they about 75% efficiency. So that could be one of the reasons why they're not controlling the VOCs in the afterburner, and that's causing the odors.
I think it would be a safe assumption.
Okay. Continued operation, the people are still complaining, getting health impacts from this.
Yes.
So what do you think, short of shutting them down, which the districts are asking for at this time, what else can they do, in your opinion, to mitigate this?
I'm not really sure, because it kind of seems that whatever material is being processed at some point in the production line, there is some form of odor being produced. I guess finding where that is would be the top priority. In what point in production, whether it's the afterburner or the actual process itself, the ovens, perhaps the ducting. I guess finding what's causing odor would be the best way to go from there.
And to your knowledge, are they making that effort to do that?
Not actively, I would say.
Okay.
Just in the hopes of sealing everything off. They've added a substantial amount of sealant to hopefully, get the cracks, but hasn't stopped the flow of complaints.
So do you, and I'm just, it's a loaded question, so you don't have to answer it. Do you think they should replace the afterburner if it's that old, depleted, and not functioning properly?
I think it's the most obvious solution. I think it would get a lot of guesswork out of the way.
Okay. All right. Thank you, Mr. Martinez.
I have two questions for you, sir. Do you happen to know what it would cost to replace that afterburner approximately?
No, I don't.
Okay, and number two, there was mentioned that the majority of the NOVs are coming from one source. Is that correct?
The afterburner?
The NOVs?
Yes.
Okay, so you said there's a total of how many NOVs? Just a ballpark.
Was it 14? Let's say a dozen, just
Okay.
give or take.
All right, so of those 12 or so, how many are coming from that one source?
From the afterburner being in production?
Yes, I'm
For the
talking
public,
about all of
I-
the NOVs.
I believe the afterburner's been in operation for all of them.
Okay, that's not
For the
my
one,
question.
for the ones
Okay,
that I've
that's
been
not
in.
my question. My
see.
question is, you're saying that the NOVs are coming from,
They're talking about the complainants?
yes.
Oh, I see.
So you said there's 12, right? 12
I'm
NOV.
sorry. I thought you were talking about the violations. You're talking about the NOV
I'm
violations?
talking about all of the physical NOVs that have been
Uh-huh.
received from the AQMD and you've gone out to the field. Okay, of all of those, how many are there total? B, are they coming from the majority of one source? If so, how many? Or a percentage of those?
There is a group of complainants that forms the core of those complaints. Every NOV has, in one way or another, there are some NOVs that have all from one group, and all of the NOVs have at least one person from that group.
Okay, so of all of those NOVs, what's the percentage that are coming from that source, from that core?
Of complainants?
Yes. You can give me a percentage. You don't have to give me a number.
I'll say it's like 80%.
80%.
Yeah.
Okay, and the complaint is the same, that they are smelling this plastic odor.
Some
What-
form of chemical like odor,
Okay,
yes.
what type of business are they? Are they businesses that have people come to, customers come in?
It's a warehouse
It's just
storage
a warehouse,
facility. Yeah,
okay.
they bring it on and ship off.
Okay, so they
Trinkets.
don't have customers that are in there that they're
No,
concerned about the odors?
no, there's no customers.
Okay,
It's just
all right.
pick up and delivery.
I just want to get a picture of what's going on there.
It's a warehouse operation, yeah. So
Okay, all right, thank you.
Mm.
Any other questions, board members? Okay, all right. Thank you, sir. All right. Have you had an opportunity to question this witness?
Yes, I would
Okay.
just
Did you
note,
have, because you looked like you had another question for him.
I would just note that the stack for the afterburner is 40 feet high. And when you stand next to it, there, when he mentioned the visible emissions, which we repaired, we were able to get a smell, but subsequent after that, I mean, you stand next to it, there's really no odor that is highly perceivable unless you're very sensitive. So every time when he comes out, I ask him,
Yes.
yeah, so
Are you asking a question?
so
sir?
it was just kind of, if it's, because okay, the question is, when you stand next to the unit, or the last few times that you stood next to the unit, you have not expressed odors next to the unit?
Well, you're
how-
speaking for him, so ask him.
Yeah,
that
well,
question.
have you, when you, the last few times that you've been out there, have you stood next to the unit and actually smelled the odors?
I think the last time I confirmed a complaint I met with you was 2 weeks ago. So on a professional courtesy, even if there is no notice of violation and we do confirm a complaint, we still meet with the person. There are times when I show up and it's just not making any smell at all. It's on, you can see heat, but you don't smell anything. The nature of the odors is very 1 minute, nothing, 1 minute, it'll be very intense and it comes and goes and comes and goes, which is why it's also difficult to determine exactly when odors are being performed, because I'll ask him, was something going on when this was happening? No, it's running normal. And then it starts up and suddenly we get complaints, or it's running in the middle of the process line with nothing being added and suddenly you get complaints. But there are times when I'll stand next to it and it won't smell at all. And then there are times when you stand next to it and it's very intense. So it's difficult to determine exactly. Standing next to it won't always give you odors. It's not constantly producing odors just by being on.
Okay. And do you know if you had any odor complaints last week?
We got odor complaints every single day.
This past week?
Mhm.
We did not get a visit last week.
No. I showed up and I wasn't able to confirm that they were actively occurring when I met with the complainants, but we received complaints every single day, including Monday.
Okay,
All right, no further questions.
okay, thank you. Thank you, Mr. Martinez. Okay, do you have any other witnesses you wanted to present, Ms. Lee?
No other witnesses.
Okay. Mr. Nurse, did you want to question your witness?
Not at this time.
Okay, Ms. Lee, do you have questions for them?
I'd just like to clarify for the record and under oath that you have reviewed the proposed conditions marked Exhibit 5 and that the facility has agreed to stipulate to those conditions.
Yes, we stipulate.
Thank you. No further questions.
Okay, board members, do you have questions for
Yeah, let me ask Mr. Castillo. You know, in the petition we saw, as of October last year, you were still paying somebody to patch up the afterburner. You know, what is the condition of the ductwork going to the afterburner?
So the ductwork does not show any emission escaping, any leaks. We've repaired all the areas that were visibly damaged, and we actually had a company come out and take a look on the inside, which they also did work on on portions of the inside of the ducting. And after the repairs were made, they expressed that they don't see any other issues.
So where are the odors coming from? When they odor, I mean, you're not contesting there are no odors, correct?
Yes.
There are times when you agree with the inspector that there have been some process or whatever you're doing that has caused odors.
Yes, so we do produce, all right, and as a manufacturing company, well, then there's obviously odors when you manufacture. I guess the extent of those odors, I guess it's somewhat, it's not exact to what he's saying, that it can all of it be attributed to us because there's carburetor business next to us. There's a bus repair station on behind us, and so there's other areas where we get odors ourselves, and maybe those can also be contributing to what their complainants are also complaining. So I'm not saying that we don't have an odor issue, but I'm just saying that there could be other things that are also influencing that.
Could also be your testing showed you have your performance is quite poor on the afterburner, 75%. That's not acceptable, especially when you have such a high inlet loading, almost 70 pounds per hour going in, and you had only 75% efficiency. Do you think a retest will show you can meet the 95?
Well, after that, we did more repairs on the afterburner when we had some tuning of the control system with Mr. Anderson's help, and contacting vendors. We were able to, I would say, increase some of the efficiency, and we also had some thermocouples and other things replaced to make sure that we're getting accurate readings. And hopefully this time around we're hoping that we get to the 95%. But if not, we have a plan to either go to the carbon capture system, or maybe find other ways to mitigate the odors.
When is your retest scheduled for now?
Well, they've given us a date of between June 20th to June 25th of this year.
Okay, so once, and then you might take a while to get the results. Once, let's say hypothetically, it still shows you don't have the required, then you would move forward to a different control system. Is that the proposal?
Well, so we're going to do that at the same time in conjunction. So if we show the 95% destruction efficiency, but there are still odors, we may still opt to include a smaller version of the system that this company is talking about. If we show 95% destruction efficiency, hopefully the odors go away, and then we don't have to invest in that new unit. But if we fail again, then we would push forward for hopefully this new unit, which the vendor has expressed confidence in meeting the 95% destruction efficiency and odors.
And we have been focusing on the VOC line and the afterburner and so forth, but you have a non-VOC line too.
Yes.
And some of the products you're using there could contribute to odors?
Well, they don't have any VOCs.
No, I know, but nevertheless, they could be, could they be contributing to the odors too? Because you have that going to a control system, correct?
Yeah, so one of your board members accurately asked, from October of last year till January, they didn't receive any complaints. And through those months, I would say the majority of the time, especially in December, only that non-VOC line was running and we didn't get any complaints on that one. So we don't suspect that they're coming from that line, but I mean,
Hello.
I couldn't definitely.
It is going to a control, our number 2, right? The
Yes.
non-VOC line, it is going to the carbon, the ESP and so forth, correct?
Yes.
What is it controlling then?
It's controlling just, I guess, the fumes that are generated from curing the PVC.
From the curing of the PVC.
Mhm.
And in the oven, it's about what, 300, 280, 300 degrees?
It's around 330, 335.
So there's the gas that's collected.
Mhm.
Has that unit been tested? Or I know there's probably no requirement for control efficiency on that, right?
No, it's a small oven, 500 beat, I think, 500.
No, I mean the control system.
Oh, it hasn't been tested, but it's maintained on a quarterly basis, and the charcoal filters were recently replaced earlier this year. So,
What about the ESP? What do you do to maintain the ESP?
every month to two, I would say on average is about 6 weeks, 6 to 7 weeks. The vendor comes in and replaces the filters, all the electrical boxes and stuff like that, and they do any repairs that the unit might need. So they come and they maintain it themselves to make sure that it's operating as intended.
Like wash down? Do they do wash down or?
Sometimes they might clean it. A lot of the times they just come and replace filters. And
You mean the ESP, the plates?
Mhm.
So that seems to have quite a high frequency. We have to replace a plate. Why is that?
That's just the way the vendor has instructed us to maintain the unit.
To replace those plates?
Yeah, they just come in, they take out these filters and other plates and stuff like that. And
Okay. Now, your product line, can any of those be contributing to, have you changed? I think I asked you this last time too, your formulation or the type of products the fabric that you are, coating?
we haven't changed any of the formulation. With regards to like the ones that do not have VOCs, we have not changed the formulation on that. We have tried, as Mr. Martinez mentioned, we have tried switching away from solvents, from VOC solvents and in our coatings to water-based ones. Unfortunately, like he said, complaints are still coming. So it really doesn't make sense to make the investment in those. The only other one that I would say that we have reformulated and we have sent out to customers to get feedback on is K-base. So we have actually eliminated the VOCs on that one as well. And if positive feedback is received, then we will update the coatings.
The K-base, that's the one with 240 gram per liter.
Mhm.
What about the Ski D?
That one has no change. We haven't produced that one. I think we produce it once every other year.
Okay.
Yeah. As far as the other ones, yeah. Our main ones are low fusion base, super adhesive base, which is LFP, SAB, K-base, neoprene, and C-base. And even C-base, we've also tried to remove the solvents to make sure that one is also at 0 VOCs.
I just wanted to go through quickly the condition. Are you the right person or to go through those proposed conditions? Or is it Mr. Andres?
Okay, is there any way to kind of summarize this or?
Well, I
condense
have to
it?
go through, I'm asking I need to check some of the condition. I just wanted to get clarification on. I don't know how you want me to summarize that unless.
No, Go ahead.
Let's see. Am I taking too long? I'm sorry. It's like
I just don't want to duplicate what they've already stipulated. If they've already stipulated, then
right, and I know they've stipulated, but I think that probably need some clarification on the condition, that's all. Otherwise, I was trying to get at, it's not every condition, but I was going to check on a couple of them. And that's specifically, let me go through. So Mr. Andreas, that I can ask the question of, or?
Yes.
Okay. Condition number 6, say shall meet the VOC testing to demonstrate compliance of the afterburner. I was going to suggest to add to meet the requirements for rule 1120 parenthesis D, because we're not really testing to see the afterburner meet the control efficiency and destruction efficiency. You okay with that language, or? I will check with the district. Yep. Which condition? Number 6. Respondent shall schedule VOC testing to demonstrate compliance of the afterburner. And I was going to put to meet the requirements of Rule 1128D. That's why, just to clarify.
Yes, that's fine.
Now, Mr. Andrews, I think can you give us a quick update what exactly you agreed on the 1147 for the burners?
Basically, we've agreed to disagree, but we've agreed.
Okay.
That we're going to do our due diligence and record the data correctly. Be supplying the information to staff. We're going to also we will submit applications to clarify and update permit conditions.
Okay, let me, in that regard, number 17, condition 17.
Yes.
So option 2, in case you have to go to option 2 and replace the burner, submit a permit application, would there be then, because it failed the test, and so will that, then you'll retest that? And I just wondered what time frame will there be a retest? And this is only if you're going to that option, the source has fails and you're going to have option 2 to replace the burner. When would you then do the retest?
Well, one of the problems would be in replacing the burner, it would add roughly 32,000 CFH of air, which could impair the residence time. So it could be a problem with the amount of time within the afterburner when you're adding that much air into the system. So one of the concerns was that we had looked at is if the burner, if it was replaced with a combustion system that controls air fuel ratio, is that going to degrade the amount of time, therefore not allowing enough residence time to be able to do the destruction efficiency? So we kind of looked at that as well. So that replacing the burner might be problematic just from a physical and technical standpoint.
So it would be more prudent if that option comes up, then to replace the whole thing?
Either replace the whole thing, and we had a quote on replacing, it was like, what, 400,000 or something of that nature?
Yeah, 450 to 500,000 to replace the afterburner.
Okay.
With a similar unit.
And I believe the system that they had looked at was an RTO, which regenerative thermal oxidizer. Right. And the problem with that could be if you're not running VOCs, then you're injecting gas all the time. And typically an RTO uses gas as a startup for, just a startup burner. And then the VOCs that are contained in the process are the ones that maintain the temperature in the afterburner. So that might be an issue as far as
right. So that's what my concern is. You have an option 2 that says submit application for replacement burner. What I'm hearing from you is that's going to be problematic because it might affect the retention time.
Yeah.
Then what's the,
our other option is to go with the carbon capture and get rid of the afterburner altogether. And that we should be able to get a quote shortly within the next week. So that would guarantee the destruction efficiency and the odor reduction.
Okay, so that's
That would be our,
option 3.
we want to make sure that if the afterburner retest proves positive, not negative, then that part of the issue may be done.
All right.
And we wouldn't have to go to the carbon capture, but we'll see see how it shakes out. But
We'll
we
get it
want to
out.
make sure we have plan B or whatever in work, so that if that is the case, we immediately apply for a permit to construct and eliminate the afterburner.
And I'm assuming that when you get the permit to construct, they will put a timeline to do the testing, so we don't need to put it here. In case you go with the new system.
Oh, the new system would in the permit conditions, it
There will
would
be a timeline
stipulate
to
a
test it.
timeframe for
Okay,
testing.
all right, yeah, because so it says submit permit application, it didn't say anything about testing, but the permit will say when to test it after that.
That's correct.
Okay. I think that's all the sort of proposed, so it's only that one minor change really on that, so I have no further question, thank you.
Okay, I have just a question and clarification, request for clarification. You had mentioned that it's a possibility that you would have a plan B on on the option to change out and then eliminate the afterburner. Would that be more cost effective for you? And then the end result save you a considerable amount of money?
It could, because we're not using natural gas for the to run the afterburner.
Mm-hmm.
So there could be a cost savings there, but there is maintenance on a carbon capture system. So it may be a trade-off or maybe a slightly positive. And I guess the biggest positive would be compliance.
Exactly. And saving money.
And saving money. That's always a positive.
Which seems like it would be a much better option.
Yeah.
So
that's why we're exploring. We're looking at making some improvements in efficiency before we do the next test. And if that doesn't prove, then we're already going to have the quotes to proceed with the carbon capture system.
Also, in regards to what the cost would be for maintenance, if you're saving that much money, you're going to have a return on that investment, which could pay for.
Perhaps. Yeah, we don't know what the final,
Yeah. I would
the bottom
run those
line numbers
numbers.
are. That would always be wonderful.
Yeah, I would definitely run those numbers.
Yeah.
And the only other thing I had, you had submitted an exhibit E in reference to the best available control technology.
Yeah.
Did you want to go over it? Did you want to, what was the purpose of you giving this to us?
The purpose was to clarify the exemption from 1147 pursuant to the BACT guidelines that indicate if the fluent goes through the burner itself,
Okay.
then it is exempt, and we still
Okay.
feel that's.
I didn't want to ignore it. I wanted to make sure that we
Appreciate that. Thank you.
took a look at it. Okay, that's all I had. Any other questions, board members? Mr. Balagopalan.
Quick follow-up, Mr. Hendricks. The efficiency test showed that the afterburner's operation is pretty dismal, 75%. Numbers don't lie. You got a high input going in. You're not getting the efficiency. Do you have any theory as to why that's the case?
We believe there is some operational considerations. For instance, a control system. We're looking at maybe updating the control temperature controller to maintain about more accurate control of the process, so there's not fluctuations in the control.
So you think the retest will prove that you have the efficiency, you think?
And we're looking at some other options as far as increasing efficiency as well.
All right, thank you.
You're welcome.
Okay, you don't have any other witnesses that you want to, or any other statements?
No.
All right, and before we do go to closing statements, Madam Clerk, are there any members of the public who have their hand raised in reference to either providing testimony or comments on this subject? Thank you. Okay, with that, no other witnesses. We can go ahead and go to a closing statement unless there was a question from my board members. No? Okay. So Ms. Lee, did you want to begin?
Ms. Hanizaveri will be providing the closing for the district.
Thank you.
Thank you once again and good afternoon, Chair Verdugo Peralta and members of the board. The district would like to reiterate that it has made extensive efforts to work with FlexFirm Holdings in order to bring the facility into compliance with its rules. I would like to note that since the last OA hearing, the district has received over 400, possibly 500 odor complaints regarding the FlexFirm facility and has been issued 8 nuisance NOVs. And speaking of the OA, I would just once again like to outline FlexFirm's inaction on some of those orders. As a reminder, FlexFirm was asked by this board to schedule VOC source testing to show compliance with 1128 by no later than October 16th. And that source test was not conducted until November 10th. The source test did not demonstrate compliance with Rule 1128, which required an afterburner to operate at or above a 95% destruction efficiency. Instead, as you've acknowledged, the afterburner was shown to have a destruction efficiency of only 74.5. Again, per your order, FlexFirm was required to submit a plan to demonstrate compliance with Rule 1128 within 30 days of receipt of a failing source test. Again, this was late. And of course, as you know, the facility has still not shown compliance with this rule. Lastly, FlexFirm was required to submit permit applications by August 31st, 2023 to modify its permits per condition 5 of the prior OA, of the original OA. And despite repeated and multiple attempts since the last OA by the district to prompt FlexFirm to submit these applications, there has been the facility has brought up other issues and has not directly addressed the specific permit application requests that our department has had, or our engineering department has had. To be clear, FlexFirm was under this board's order to complete these tasks and did not. This board also acknowledged that FlexFirm needed to work with the district to assess the applicability of Rule 1147. Again, I don't think we need to reiterate that consensus was not reached until a couple of hours ago, and it would have been helpful had the facility been more responsive and clear in its responses during the period of the original OA. So I just want to kind of wrap up by emphasizing that the hearing board's order was not a list of suggestions. It was a directive for FlexFirm to take specific actions by specific dates to come into compliance. As we sit here today, I'm not sure that we're in a much better position than we were since last July. And while we would like to acknowledge that FlexFirm has indicated in recent weeks that it is working on potential ways to minimize odors, either through this carbon capture system or other efforts, we would also like to acknowledge that this work should have been done already. So as we sit here, I just don't want to forget to acknowledge that the district staff has spent significant resources addressing odor complaints at the site multiple times a week, and that the folks surrounding, and the surrounding businesses have suffered, because of the odors. There have been complaints of headaches or sore throats or watering eyes and physical symptoms that should not be happening. So today's request for a modification represents FlexFirm's last chance to comply with district rules before other drastic steps are taken. And we urge the board to grant the district's request for a modification with the understanding that FlexFirm, that the district will not be providing additional opportunities in the future. With that, we thank you for your attention, and we hope that you grant the modified order with the conditions as stipulated to by the parties.
Okay, Mr. Evers, did you want to go ahead and provide closing statements?
We feel that we appreciate working with staff. We have submitted some of our complaints, or not complaints, but concerns about the way that staff is looking at the exemptions. We still believe that the exemption should exist, but we are at the same time proceeding forward with another source test in between now and then, looking at a number of ways to mitigate the low compliance and eliminate the odors at the same time. So there is ongoing efforts, and they've continued to work with vendors to fix a lot of the problems that existed last year. And as previously indicated, we have spent something over $40,000 in the process of trying to mitigate the issues. And the first source test that was scheduled for, I believe, October 16th, the source tester said there's issues here. We need to reschedule this because they saw some issues. I think there was an opening where there were some emissions coming out, and they said, fix that. We will go and reschedule the source test. That was basically why that source test didn't take place on the first day. There was an effort made to comply with it. They were there. Mr. Martinez was there at the time, if I'm not mistaken. So we are proceeding to increase the efficiency, and with those increases to a source test, at the same time making sure that we have a plan B that would satisfy all the requirements of the rule. So we're on it, so to speak.
Okay, thank you.
If I may, just really quickly, since we don't have a date for the September hearing and we're still open without needing to, reopen, maybe we can decide on a
Yeah,
date.
I just was handed the book to
Okay.
go ahead and try and figure out a date. So,
I'm supposed to be in jury during the week of June, the 16th of September.
So why don't we do September 10th?
September the 10th.
And we also have a hearing on the 24th already, or not?
Let's see.
No. 10th is fine for me.
10th is a Tuesday.
No objection from the district.
That would be acceptable to us.
Okay. The 10th. I'm not going to write it in ink, so I'm going to let you do that. Okay, so the 10th. Sounds good. All right.
All right, are we ready for the motion?
Yes. Well, actually, we need to deliberate first in reference to finding good cause for this order of abatement, and that it is a stipulated order of abatement. I, for one, do see the effort, but I'm not sure that it's being taken as seriously as was stated by the district, because these are conditions, and as was stated, they're not suggestions. They're absolute with dates, and they're absolute with protocols. And I just want to make sure that you understand that and seriously do look at other options to mitigate, but also to save yourself some money as well. And with that, if all of that, if you're going to agree to that, and the parties from the district have been, I think, they've bent over backwards to try and get you to that point, I can find good cause. Board members?
Yeah, I think I agree with Ms. Honey Farah's statement. This is the last chance, really, next to shutting down the facility. So I think you should take it seriously, because the ongoing complaint has not stopped. It's still ongoing. It looked like there has been, the impression I've got from what I've heard is it's been poor maintenance, but you keep saying patching holes, in the afterburner. They couldn't do the source test because there were some holes there. I mean, air was getting in. So it just get the impression that there's, maintenance of the equipment has got a lower priority. So your efficiency is very low, for that kind of input. it should be the high 90s. It's unacceptable to be in the 75. Something else is going on, you know. So I hope your retest proves otherwise, but you know, it looks like you may have to change out your whole, replace your system, in my opinion, or get to improve your order. You know, I think it's you need to take a holistic approach. Look, not just the focus on the afterburner and the efficiency, but what else is contributing, whether they're fugitives, you know, the other line, so that, you know, it's unacceptable to get that many complaints in continuing, you know, people are complaining and they're feeling the health impacts from the orders, even though you sort of dispute whether it's coming from a facility. But I think the inspector has done his due diligence and pinpointed your facility as a source, you know. So I think we're going to go with that. So if the district comes again and says, shut your facility down, I won't hesitate, you know, the next time. Just leave it at that.
Mr. Pearman.
Yeah, I agree. Good cause exists to issue the stipulated modified order with the date changes as described by counsel for the district and the one Mr. Pond suggested, as well as the hearing date next time on September 10th.
Any other comments from board members?
I
Okay,
can make a motion.
go ahead, Mr. Ali.
All right, in the matter of Flex Firm Holding LLC, 2300 North Chico Avenue, South El Monte, California, 91733. That case, the facility ID is 187620. Case number 6239-1. I proffer that we find good cause to grant an order, a modified order of abatement as set forth in the proposed findings and decision document, which is designated as Exhibit 5, with all of the amendments as stated within the record from members of the hearing board, as well as the respondent and the petition, having been confirmed by the clerk as being acceptable.
I second.
Okay, any discussion on the motion? All right.
Just to clarify, I think that it wasn't, Exhibit 5 was the proposed modification to the condition, not the finding a decision document. I'm assuming that's a separate document that'll be prepared by the agency.
So the document that we have, of conditions,
The proposed modified
Exhibit
conditions
5.
is number 5.
Number 5, it is number 5. I think you said finding a decision, that's all. I say it's a proposed modification
Right.
to the finding a decision document.
Okay, but I have Exhibit 5 in there, so we're clean for the record,
Yeah,
right? Madam
Number
Clerk?
5,
Okay.
yes.
All right, good deal. Thank you, Mr. Bullock.
Sure.
Okay, and we have a second? Okay, and any discussion on the motion? All right, and Mr. Ali, how do you
Aye.
vote? Mr. Balagopalan?
Aye.
Mr. Pearman?
Aye.
And I also vote aye, so it is unanimous. We have found good cause for the order of abatement. I want to thank the district very much for trying to help the company get to this point. And thank you, sir, for being cooperative, and hopefully we will have a successful ending to this.
We certainly hope so
Thank you so
for
much.
everybody.
Okay.
Thank you so much.
Thank you. All right, and Miss Lee, are you going to be writing up the findings and decisions?
Yes, we'll be providing the proposed findings and decision, but I want to run it by Mr. Andres so he can confirm before we send it to the
Okay,
clerk.
great. Sounds good. All right, with that, we are adjourned. And there are two emails that came from Dale Larson regarding tomorrow, I believe. So
Look at it. All right, dude.
you can stop the recording, Day. I thought that was good. Right here.
Well, I'm not sure if
Oh, yeah. Yeah, hold on. Yes, of Rule 1128D, Davis and David.
Good deal, Miss Rosalinda. Are you in the cafeteria?
Still making to this house now. Oh my goodness. Do they? Later. Thank you. Bye. Thank you.
All right. Did, he didn't vote, right? He left, doctor?
Yes, he had an emergency.
Oh, emergency, yeah.
Oh, he left.
He left, yeah. So it's 4-2.
I mean, it's just went to the back.
I honestly thought he had told you.